My lord, if I may kindly seek your lordship indulgence in respect of item 2 of part 2. My lord, there has been an agreement, a compromise between the parties in this matter, and if this matter may be disposed of today itself after part 1.
Item number 2, part 2. Who is the counsel for the appellant?
I'm the counsel for the appellant, my lord.
Let's see the record. Outside court or at Lok Adalat?
Outside court.
So you want to dispose this in terms of the agreement that is arrived, or you want to
Yes, my
withdraw?
lord. Yes, my lord. On the basis of the terms and conditions laid down in the agreement, my lord. A copy of which is available with us. We can submit the same.
What is the appeal about? The
appeal is
the case, the background of the case?
my
Yes.
lord, it's encroachment, overlapping of the land of the respondents, land of the appellants, my lord.
But nothing in terms of conditions of the nothing is
My
here.
lord, the map. It was made.
Andoya
the agreement-
Kantala nang yan, and then just the map. So
Just
what
the map, my
what
lord.
is the map? Nothing, no explanation.
My lord, that is what they have, the landowners have been
It was
committed to
done,
us.
my lord, it was done
So the
without
purple
council's-
color, the purple color is to belong to the
Respondent.
Lal Hazwala. Okay, respondent, and the
Ke Thangjola
greenish yellow
and-
color, light greenish yellow color is to belong to the. Who is this person then? Ketanzwala is the respondent, and the appellant is Kethansiami.
Appellant is Ke,
But the name of the appellant is not here.
appellant number 2. Appellant number 2 is Dr. Leng Haya. He died and substituted by his son, Malsom Dong Liana, my lord.
Appellant.
This
Okay.
agreement was made between Ke Thangjola, who is the respondent herein,
Yeah, let's see the names.
my lord.
Kethansiami and two
Ke
others.
Thansiam is the respondent number 1.
So-
Number 2 is, in fact, my lord, appellant number 1 sold the disputed land to the respondent number 2 and 3.
Okay, so this person, Mal Somdong Liana, is respondent number.
2
Okay.
substituted his father, my lord.
Okay, so no, the present respondent number 2, we'll just say that.
my lord.
So we will dispose it off on the grounds that in the drawing, the light purple is supposed to belong to this, the respondent, no, the respondent, and the light green color,
My lord.
yellowish green, is supposed to belong to the petitioner, no, the appellant number 2.
Yes, my lord.
Is it?
Appellant number 2, yes, my lord.
Number 2, and this is the respondent number 1. How many respondents are there?
There are 9 respondents, my lord. However, the respondent number 1 represented all of them. They are the children.
Okay,
My lord.
representing all the respondents.
Yes, my
and
lord.
appellant number, what about appellant number 1?
One-
Have they also signed on the agreement?
Respondent number 1 did not have
Appellant
anything to do,
number
my lord.
1.
Appellant number 1 did not have anything to do with the present present agreement, my lord, since she was having no problem with the other
But
party.
she has filed the appeal.
After selling the disputed land to the respondent, to the appellant number 2 and 3, my lord, she did not have any part to play in the present case.
So you are also representing appellant
I
number
am
1?
representing all of them.
Okay.
In fact, respondent number 3 already settled the matter with the respondent earlier. Your lordship has already passed order to that effect.
Okay, I don't remember. Anyways, okay, so this is the terms of the agreement. This
Right,
is
my
the
lord.
drawing. So in terms of, as per the drawing,
Yes, my
we'll
lord.
dispose it off accordingly.
My lord, my lord.
Yes. We'll pass an order later. This is the first case.
Seek your lordship's indulgence in mentioning part 2, item number 1. My lord, Mrs. Linda is having personal difficulties today, so she has requested me to list the matter for tomorrow.
Which one?
Part 2, item number 1, my lord.
We'll list it on Thursday. During this week, anytime.
Yes, my lord.
Okay. But if you want this thing, we'll fix it on maybe on a Thursday. Okay, tomorrow I have some other engagement. Yes.
Obliged.
My lords, I beg to mention item 12 from the supplementary list, my lord. It's in the hearing column, my lord.
Yes.
My lord, in fact, this is a criminal appeal and it was initially handled by Mr. Bilaram Enga. But after the appeal was admitted, my lord, the appellant had submitted a letter to the inquire the matter whether who will be appearing for the appellants. So, my lords,
So who is appearing? Anything in the note? So where's Mr. B. Laramenga? He was initially appointed, isn't it?
no, he was appearing as a private counsel, my lord.
Private counsel.
Yes.
So you talked to Mr. B. Laramenga.
My lord,
Is
I'm
he
here on
going to
behalf of
appear?
my-
Yes.
Yes, my lord.
Have you withdrawn?
Yes, my lord, we will withdraw and we will no longer take up the case.
But here, this last court's order, it says that does not find any order issued by this court directing the appointment of legal aid counsel. Then how were you appointed?
I was appointed right order 29/5/2024, my lord, issued by the Secretary High Court Legal Services Committee. It seems the appellant has directly approached the legal services, my lord.
You see, okay, so during this time, Mr. Guike was the member secretary. No, he was the secretary of the High Court. Okay. Let's see Regulation 52A of the Legal Service Authority Regulation. This is the Mizoram State Legal Services Authority Regulation, 1998. So we're going to have the hearing today, or want to pray for adjournment?
No, my lord, I have not been furnished a copy of the paper book also, my lord. And notice will have to go to the respondent number 2 as well, my lord.
Okay, at this stage, you just make mention for adjournments.
My lord.
Just you wait for some time.
My lord.
We'll see later. Let's go as per the list. It's not a simple matter. We'll have to see the regulation also. Get a copy of the regulation. You were appointed as per the regulation.
My lord.
Okay. So let's see what does the regulation. We read with that. Have the copy of the regulation. You have the appointment letter?
My lord.
Yes. So you are appointed in terms of the regulation of the Mizoram State Legal Service Authorities Regulation 1998. If we don't have it here, have the copy,
My lord.
and then after the usual this thing, we'll call out the matter. Yes.
Lordship, may I seek your lordship's indulgence on mentioning item number 6 and 8 of the hearing list, my lord?
Hearing list 6 and 8.
Yes, my lord. If these two matters may come up on Thursday, I may take it up on Thursday.
Both of them.
Yes, my
We
lord.
have another matter which is going to be taken up on Thursday also. We can do it on a Friday also. List one for Friday and list one for
My
Thursday.
lord, with regards to item number 6, this case is being handled by Miss Mary, and her daughter is in the hospital. She's being hospitalized. So she will not be able to
Then,
attend the court for this
so
week.
are you going to take up the matter?
No, my lord, this is a criminal appeal. Item number 6.
Yes. So if the additional PP is not available, there's another additional PP, you're the other additional PP. You can collect the files and take up the matter. There's so many of you. How many of you? 3.
3. Yes, my
So
lord.
you can help each other if, or what? In the next week? Will she be available by the
Yeah,
next week?
yes, my lord. She has requested me to list the matter next week.
So we'll list it in the next week.
Okay, my lord.
It is submitted that the additional PP due to the sickness of her infant child has prayed for adjournment of the matter for the next week. In view of the above, as prayed for, list in the next week. Yes. Then 7 is what? This we can list it on maybe. Yes, on Thursday you want
My
it.
lord, Thursday.
During this week on Thursday.
May I seek your lordship indulgence for mentioning part 2 of item number 7? Your lordship, my senior, Mr. Johnny L. Totong, is out of station and he will be till the first week of this December.
Item number?
7, part 2
Now,
of item number
the
7.
council just now appeared for item number 7. Talk to each other.
No, my lord,
No,
I'm
it's-
for item 8.
Okay, 8.
Yeah.
Okay, 8 is for Thursday. 7, adjournment.
If the matter may be listed after 3 weeks.
Have you spoken to the respondents? Government?
Yes, my lord. Miss Mary is appearing in this case.
Okay, no objection for 3 weeks. Mention is made on behalf of Mr. Johnny L. Totong, learned counsel for the petitioner for adjournment of the matter since the learned counsel is said to be out of station. In view of the above, as prayed for, list after 3 weeks. Yes.
Oh, may I seek your lordship indulgence in making a mention with respect to item number 5, part 2, my lord.
Yes.
My lord, if this matter may come up on Thursday or as per the convenience of the court.
During this week, let's see on Friday.
Yes, my lord.
Tentatively, we'll fix it for Friday. Let's see.
Yes. And
Please inform the councils for the respondent.
yes, my lord, we have consent from the other parties.
Yes.
And with respect to item number 9, my lord, if this matter may come up tomorrow, if possible. or
Tomorrow, I will not be able to sit for a long time.
Okay, my
So
lord.
we'll make it in the next week
Yes, my lord.
on the submission made by the learned counsel for the appellant. List in the next week. Yes.
Much obliged.
My lord, with respect to item number 11.
11.
Yes, my lord. My senior is, he could not make it today, so I kindly prayed time for about a week. He's indisposed today.
Okay, so in the next week,
Maybe after 2 weeks, my lord, if
2 weeks.
possible. Yes, my lord.
is it okay?
Yes, my lord.
11.
On the submission made by the learned counsels for both the parties, list after 2 weeks.
Much
Obliged, my lord.
obliged.
Part 1, motion, item number 1.
Please, Your Lordship, this is an application under Article 226 of the Constitution of India. My Lord, the brief facts of the case of the petitioner is that his land was acquired in terms of award dated 1/7/2021, passed by the Additional Deputy Commissioner, wherein he was awarded compensation. However, 15% of compensation amount was deducted from the compensation by way of
Compensation
revenue
under
cess.
which act?
3G.
Pardon?
Oh, sorry. National Highway Act 1956.
National Highway Act.
Yes, my lord.
So,
The respondent,
so just
Has-
read the first paragraph of your synopsis. to pay rehabilitation and settlement entitlement as provided under the second schedule of the right to fair compensation and that is the 2013 Act.
My lord.
So if it's under the national highway, then you're supposed to pay what? Compensation under the 2013 Act. Is it?
My lord, for making the assessment, the National Highway Act had also provided the second schedule.
The National Highways Act.
Yes, my lord.
What about the right to fair compensation and transparency in land acquisition? It has to be read together or what?
My lord, same thing.
Is it read together?
Yes, my lord.
Okay, so if it's under the National Highway Act, then you have to refer to the second schedule of the 2013 Act.
My lord.
Okay. Then what happened?
My lord, when the petitioner was awarded compensation, 15% of compensation amount was deducted by the respondent by way of revenue cess. If I may take your lordship.
Let's see the National Highway Act, second schedule of the 2013 Act. I'm not very sure. I don't know. Where does it provide? Just show me. How is it done? I'm not very sure, so I want to be, I want the clarification actually. So you're saying if the acquisition is done under the National Highways Act of 1956, acquisition is done by that, then the assessment will have to be calculated as the second schedule of the Right to Fair Compensation and Transparency Act, is it?
My lord.
Let's see the second schedule. I'm asking you because I'm not sure whether this thing is correct or not. So you please clarify that confusion of this court. So I'm looking at the 2013 Act where any acquisition that is taken, where's the second schedule? I just want some clarification, that's all. I'm not questioning the correctness or anything, just show me. Because you're referring to the two acts, National Highway Act and the 2013 Act. So how are they connected? Let's just see.
Notification.
Second schedule. You have the act? So under the National Highways Act, you don't have a provision, same provision?
Well,
so you mean to say when any land is acquired under the National Highways Act, the compensation is made under the 2013 Act, is it?
yes, my lord.
The National Highways Act is not complete in itself? Yes, Mr. Victor, just explain, because I myself am not very clear. That's why I'm asking
My
you.
lord, an ordinance was made by the government
Yes.
stating that even if the acquisition proceeding was done under the NH Act, this schedule will be followed.
Okay, where's that?
It's not with them.
Okay, but there is one, an ordinance. Ordinance will be effective for how many months?
That I cannot,
It will be for 6 months, and then it will have to be made into this thing. So when acquisition is done, let's clarify this. I'm not sure myself. When the acquisition is done under the National Highways Act, then do you have to refer to the 2013 Act when acquisition is not done under the 2013 Act? And then you say there's an ordinance. Then the ordinance will have to be extended, isn't it?
besides this, my lord, please the award of compensation for the land value. There is this, they used to pay for the rehabilitation and resettlement also. And
No, just,
after the ordinance was made, there was an order subsequently issued on 28 August 2018 to that effect.
okay, okay. That
for the
for
completion of-
calculation of the land acquired under the National Highways Act, it is the 2013 Act, second schedule will be used.
Yes, madam.
Okay. Have that a copy ready, isn't it? Though it's presumed that we're supposed to know, but unless we have it in writing, then there's that confusion. Yes. Okay, good enough. Then. So acquisition was done under the National Highways Act.
My lord,
And then yes,
the petitioner was awarded compensation. There was a,
yes, okay, 15% says deducted,
Yes, my
but you
lord.
say it's not,
it was not acquired by the government, state government, but the
okay,
revenue
will issue
cess was
notice, will
deducted.
issue notice, fine. So you want your 15% back, is it?
My lord,
Deducted by the state?
state respondent.
Yes.
Kala.
Heard Miss Mercy.
Respondent number 3. My lord, if the matter is squarely covered, it's a covered matter. If I may take it, your lordship,
Will issue notice and find out whether it's covered. Is it
Yes,
covered?
my lord.
It is covered?
Moreover,
You
the
admitting?
they have submitted their representation to the respondent number 3, Kala. Kala is not being represented today, my lord.
But even if it's if it's a covered matter, so do you agree that it's a covered matter? Can we dispose
will
it
have
off
to
in the
clarify
motion
that,
stage
my lord.
itself?
If it can be fixed on a short date, I will have to clarify whether it's a covered case or not.
If it's as simple as they say, it appears to be covered, isn't it? Anyways, we'll give you time, we'll issue notice today, a short date, you find out whether it's a covered matter or not. And then we can dispose it off in the next date. Covered matter by which judgments of this court? Coordinate bench of this court, is it?
yes, my lord. I have annexed,
You have annexed them?
yes, my lord.
Okay, so the copies of the judgment also will be in the notice which is going to be served to you. So you have a look. Yes. Heard Miss Mercy, is it?
My lord,
Lalshet Luang, learned counsel for the petitioner, who has filed the instant petition. Petition under Article 226 of the Constitution for issuance of the appropriate writ or order for directing the respondents number 1 to 7 to pay okay, to pay rehabilitation and resettlement entitlement as provided under the second schedule of the right to fair compensation and transparency in land acquisition, rehabilitation and Resettlement Act, 2013, within brackets, 2013 Act. Okay. The case of the petitioner is that the petitioner is the landowner of periodic Pata number 54 of 1984, having an area of 4 bighas located at Tuirinikam, Kaizol Lui, Tlang, Tlang, is it? Tlang, Saitwal district, which was acquired for widening / 2-lane with paved shoulder / 4-laning, etc. Maintenance and management and the operation of NH-6 within brackets NH-53. In the district of Saitwa. The petitioner's land was acquired in terms of the award dated 01/07/2021, passed by the Additional Deputy Commissioner, Saitwal District, full stop. However, 15% of the compensation amount awarded had been deducted by respondent number 3 by way of revenue cess, full stop. There is no provision for deduction of the 15% towards revenue cess under the National Highways Act, 1956, or the Rights to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act, 2013. And the said deduction being a violation of Article 13 and 300A of the Constitution of India, the instant writ petition has been filed. Issue notice to the state respondents,
1 and 2, my lord.
number 1 and 2. Issue notice to the respondents. Miss Caroline K. Lamupui, learned government advocate, accepts notice on behalf of respondents number 1 and 2. While Miss
Baby Lardin Zwali.
Baby Lalrizwali
For respondent number
accepts
4.
notice on behalf of respondents number 4. And Mr. Samuel so-and-so accepts notice on behalf of.
5 and 6.
You are the standing counsel?
Yes, ma'am.
Okay, standing counsel for respondent number 5
And 6.
5 and 6.
and 6. No need to issue formal notice. Are you all represented? What about respondent number 3, I think?
3 is the Kala, my lord.
Not represented today.
No, my lord.
Notice be issued to respondent number 3 through registered post with AD within 3 days, returnable by
My lord.
3 weeks.
The Kala is Miss Lalnga Isaki Fanai.
Government advocate is not representing, is
No,
it?
my lord, it's a different body, so we are not
Okay.
representing.
List after, yes, 3 weeks.
My lord. Oblige.
Item 2.
Wait, before that, you said it's a covered matter, isn't it? Before issue notice, the learned counsel for the petitioner further submits that the instant writ petition is a covered matter and has duly enclosed the judgments of the coordinate bench of this court with regards to the said matter. Okay. Then, before, list after, 3 weeks, okay? The learned counsels for the respondents to
My
verify
lord,
whether
if
the
it can
said
make it 2
matter
weeks.
is a covered matter. Yes. Yes.
If the matter, 2 weeks.
I will make it 3 weeks because the Kala, let the Kala also be represented, notice, okay? Yeah.
My lord,
Item 2.
Yes.
Yes, my lord, may I please your lordship. My lord, this is now the third time this writ petition is filed. And I was joining the Indian Army as medical officer, and upon finishing my term of service, I then rejoined the respondents, joined the Mizoram University, as medical officer under Mizoram University, my lord. And then earlier I had filed one writ petition, which is WPC number 32 of 2008 for protection of my earlier pay while I was working as while I was working in the army, that is grade pay of rupees 6,600 in pay entry. My lord, upon joining the medical officer and under the respondent authority, my grade pay was fixed at rupees 5,400, my lord. And further, upon completion of 5 years in that capacity, as grade pay of rupees 660.
Okay, this matter, the same issue was filed in WPC number 32
Yes, my
of
lord.
2018.
Yes.
Where this court had said that since you have submitted a representation, that representation should be disposed of
Yes,
first.
my lord.
Okay, then what happened?
Then if I take your lordship to para 4 of the synopsis, my lord.
Yes.
There is a
Okay,
At
the
the
way
fourth
the
line.
High Court disposed of the previous writ petition. Huh?
Yes,
Read
yes.
the para, yes,
para 4 and 4 line.
yes.
Therefore, without entering into the merit of the case, the court is of the view that the respondent authorities should consider his grievances, particularly in the light of DSE scheme conveyed by the University Grant Commission UGC to all the registrars of central universities and UGC maintained deemed to be universities on 3/9/2011. The communication dated 12/8/2000.
What is this deemed to be universities on 3/9? What is this? This is a date. What date is it?
Yes.
It cannot be 3/9/6/2011.
Yes, my lord.
Make the correction now only.
Just a minute, my lord. There
This
is
must be a typing mistake.
at page 53 of my
What is the
petition.
correct date?
Page 53 of my petition. If I take your lordship to page 53 of my petition, my lord.
53.
13th line from the top, my lord. That is this honorable court order.
So what date is mentioned?
It was written as 3/9 and 6.
But you
of
should
2011.
know, you should know the correct date
Yes, my lord.
because okay. There must be something wrong with this. What
Yes.
is the correct date? What is supposed to? This is a typographical mistake, obviously, because they cannot. Or is it three? Are there two?
Yes, there might be two dates, my lord.
There might be. This is your case, isn't it?
Yes.
So
9/6/2011, my lord.
it is 9/6.
Yes.
This tree is a mistake, isn't it?
Yes, my lord.
Typographical mistake which has been made by this court, huh? Okay. So it's 9/6, huh?
9/6/2011.
Continue reading.
And without considering the observations made by this honorable court, my first representation was disposed of by the respondent authority.
How
Then
is it
after that,
disposed of? How?
after that, I filed one contempt case.
Okay, what happened to the contempt case?
At page Roman number 5, my lord, I've written in the synopsis. And in that contempt case number 7 of 2023, the Honorable Court did not find willful disobedience. However, I was given the liberty to take up the issue before appropriate forum. And then I filed another writ petition, my lord. And the same was registered as WPC 65 of 2024. However, that was withdrawn with liberty to file a fresh due to certain defect. Now, we approach your lordship with a prayer for with a prayer to as to why my past military service shall not be counted for fixation of my pay and shall not be fixed at rupees 6,600.
Okay, let's look at the rejection of your application, representation made by the respondents. On what grounds was it rejected?
At page 68 and 69, my lord.
The matter has not been decided on merits so far, isn't it?
Yes, my lord.
So, on page 60?
68 and 69 is
Ah.
a reply to my
Okay,
presentation.
let's read this. So in your contempt petition, you had said that it was not considered in light of the DACP scheme.
Yes, my lord.
What does the DACP scheme say?
DACP scheme is the Dynamic Assured Career Progression Scheme.
So what does that say?
So, according to that scheme, I was supposed to enjoy the pay protection under from my earlier service, my lord.
Okay, let's see. Read page 68.
Page 68. Pursuant to the Honorable Court's judgment, High Court judgment and your representation referred to above, the following facts and circumstances are furnished in order to highlight the issues of not acceding to the demands raised in your representation. Number 1, Dr. Max Chan Lenin was appointed as medical officer under one reserve quota of scheduled caste in the pay band 3 of rupees 15,600 to 3,900 plus 5,400 GP. His appointment was under direct quota and his pay was fixed in its initial stage. The very fact of his ex-service status as Army Medical Doctor Major does not confer on him extraneous benefit other than protection of last pay drawn in the pay band.
So the reason in the first paragraph, if I'm not mistaken, the reason why it was not done, as you said, under the DACP scheme was because your appointment was under the direct quota.
Yes, my lord. They say it was under the direct quota.
And you're saying it is not. You can still claim your status of your previous appointment as
Yes.
ex-service.
Yes, my lord. Because
So they have explained in para 2 why they don't accept it. Just read.
Dynamic Assured Career Progression Scheme, white letter number so-and-so, dated 9/6/2011, is devoid of mentioning its admissibility to armed force medical doctor under the Ministry of Defense of India. The Mizoram University, therefore, is not in a position to count the 5 years previous service of the petitioner, that is from 2006 to 2012, in Army Medical Corps for want of specific order from competent authority. Therefore, Mizoram University is under constraint to consider his entitlement of upward movement under DACP effective from 8/11/2013 only, i.e. his date of joining in Mizoram University as medical officer. As he went in as number 3, as he was in short service commission, he was bound to resign from the
Short
post.
service commission, I think it's for just 5 years. And
Yes.
then they leave the service, isn't it, when they join the
Yes, ma'am.
army in whatever capacity?
He was bound to resign from the post he held in the Armed Force Medical Service. After putting in a certain number of years, as such he had resigned
Resigned.
from the said post on 1/2/2012. After that, he joined Negrim Shillong as senior resident doctor with effect from 7/2/2012 to 22/2/2013. Provide copy of appointment, etc. at Annexus 4. Subsequently, he joined as medical officer in Mizoram University after a gap of 9 months and 13 days. At this period, as this period is considered break in service, as fixation of pay of employed pensioners, orders 1986, Annexure 5. It is to be understood that service combination as per CCS rules envisage service without break, suppression of his service at Negrims at the time of applying medical officer's post at Mizoram University in itself appears inconsistent and unbecoming of responsible army officers retiring. The army certificate of Dr. Lenin's past service is eligible to be counted towards Mizoram University for all purposes needs further examination. Number 1, that he having been retired as short service commission officer in the grade pay of rupees.
So they have explained why you have not been considered. So now in your petition, have you mentioned their reasoning? What is wrong with their reasoning?
Yes,
With some authorities, some rules, or simply saying that I want it, so I must have it? They have clearly given the reasons as to why the DACP scheme is not applicable in your case. You have it is a short service short service commission only for 5 years. After that he retired. Then after the break he's re-employed. So and therefore so they said there's a break in service. Okay. So and therefore in your writ petition have you
Yes, at
countered
para
all the
21,
findings
at para
as to
21.
why with some reasons or what, or simply I want it, so you have to give it to me.
At para 21, I have made my
At para 21,
yes, para 21 of my petition.
I'm just trying to find out whether you have a case or not. Yes.
The
What is your reason?
a refixation of the pay of petitioner as communicated by letter number dated so and so in accordance with Rule 7 of CCS. Fixation of pay of re-employed pensioner orders 1986 could not be accepted by the petitioner on the ground that the same is not applicable in respect of person re-employed after resignation, removal, or dismissal, provided they have not received any retirement terminal benefits for the
Okay,
pre-employed
so
service.
you're basing this on what?
At this stage, my lord, I have not enjoyed any retirement benefit from the army or from the Negrims, from my past service. So I am entitled to enjoy the DACP scheme. Yes,
Okay, because no pension, nothing was given to you.
yes, my lord.
And then you joined after you retired. Okay. Short service commission, they leave after that.
Yes,
Okay.
ma'am.
They cannot continue.
Yes, ma'am.
5 years in the army. Okay. So after the term of 5 years is complete, you were re-employed in the university. So you want the benefit of your 5-year service to
Yes,
continue.
my lord.
But anyways, I don't know whether you'll have a case. You'll
At
have
this
to
stage,
base
my
the-
humble prayer is that let not this be
You
issued, my
see,
lord.
then you'll have to, because they have clearly explained while replying to your representation as to why they cannot consider the applicability of the, what is that called? Yes, that scheme. Okay. So you'll have to counter all those reasons which
Yes,
has
madam.
been given by them in your writ petition. Why the reasoning made by them for not accepting your representation is wrong, which I don't think you have done in your writ petition. Anyways, you'll have to see. So what you should have done was counter the reasonings made by the respondents. You'll have to address that, which I don't think you have addressed. Anyways, you can always do that in your affidavit in reply if they make a counter affidavit.
Yes, ma'am.
Yes, yes, heard Mr.
Lalbiak nung nam.
Lalbiak Nunga Namte, learned counsel for the petitioner, who submits that the instant writ petition is filed for the protection of his earlier pay while working in the army where he had worked as a short service commission as what?
Major.
After completing his MBBS
Yes, my lord.
in the Army Medical Corps. Thereafter, after the completion of his 5 years term, wherein he was given the great pay of rupees 6,600 in pay band PB-3. However, after joining the post of a medical officer under the what? Respondents, you just mentioned
In
respondents.
Mizoram
Who are they?
University, my lord.
Under the Mizoram University, the respondents, make it the respondent authority, had fixed his grade pay at rupees 5,400, whereas the petitioner is entitled to be given a great pay of rupees 7,600 on his completion of 5 years in the capacity as great pay of rupees 6,600 under the benefit of Dynamic Assured Career Progression Scheme within brackets DACP scheme, close bracket. The petitioner had earlier filed a writ petition number 32 of 2018, which was disposed of by this court by directing the respondent to consider the representation of the petitioner. In light of the DACP scheme conveyed by the University Grant Commission within brackets UGC to all the registrars of central universities and UGC maintained deemed to be universities on 09/06/2011. Full stop. The respondents, however, had rejected his representation by holding that the petitioner is not entitled to the benefit under the Dynamic Assured Carrier Progression Scheme, within brackets, DACP scheme, close bracket. And hence the petitioner has approached this court the second time. Issue notice to the respondents. Miss
Yes, Miss Rudalwat Peli.
Ruth
Correspondent number,
Kelly
the
accepts
respondent.
notice on behalf of respondent number
There's only one, my lord. There are 1 and 2.
1 and 2. How many respondents are there?
True, my lord.
2.
Okay. No need to issue formal notice. List after 3 weeks.
Obliged, my lord.
Requisite copies of the writ petition to be duly furnished to the learned counsel for the respondent. Yes.
For admission, item 3.
Yes.
Your Lordship had already heard this matter 2 weeks back. And the government advocate was asked to obtain instruction in respect of that division bench order, which upheld the decision of this honorable court regarding
Okay, this is the
inapplicability of the
writ
2016 Act.
appeal.
Yes, my lord.
To
And
disallowed. Yes, yes.
in the meantime, my lord, last week, the coordinate bench of this court had rendered judgment, which meaning thereby the present case is squared in covered with the recent judgment of this court.
Okay, so we had allowed the government advocate
Yes, my lord.
to get instructions whether the writ appeal 71/2018 is being appealed against by the state, isn't it? And yes, so Miss Balsam,
Yes, Lordship, at this stage, there is no decision or an intention to
Oh,
file
so
an
you don't
appeal
know to
to the higher
okay,
forum at this stage.
then under
So the
such
matter can be disposed of
circumstances-
since the
Oh,
coordinate bench
of this
has
court.
already disposed of some other matter, the same matter, Lordship, last week. So
Okay,
it can be
so-
disposed of in that line, Lordship.
So your land was acquired
Under the Act of 2016.
and compensation amount was given to you
Yes, my lord, it has been paid, but they
under
have,
the condition, is it?
yes, my lord, with the condition that subject to the outcome of the writ appeal. No prejudice
So
will
writ
be
appeal is in
caused
your
to the
favor. So the
landowners.
remaining amount, which is, no, so it will be basically the interest.
Yes, my lord,
It will
plus,
have to be calculated at how much? 100%?
yes, my lord,
And what else?
and cess,
Okay.
cess.
The
As well as-
cess, 15% cess to be
In this
returned.
case, 10%, my lord.
Okay, 10% in
Yes,
this
my lord.
case has to be returned.
Yes, my lord.
So previously, your interest under the 2016 Act was how much? You were given an interest of how much? Under the 2016? 2013, pardon?
12% interest was paid.
12%. So that has
madam.
to be now increased to 100%.
So let's
And
give
the-
100%, yes.
Yes, and the cess which was taken is to be returned. Now
Yes, madam.
concerning the return of the cess amount, how much will the total come up to? Tentatively, any idea?
Yes, my lord, I have mentioned it. It's only rupees 29 lakhs 15,000.
29, okay, where have you mentioned that? I'll pass the order later so that.
Yes, my lord.
we have
It's in para 7, my lord.
para 7.
Page number 18, 19. This is the extract of the cess
Okay,
amount.
yes, so it's here. And the amount is, okay, 29 lakhs
Yes, my lord.
15,000. This,
And-
okay, this amount. And then besides that, besides the 12%
Yes, my lord.
interest already drawn by you,
Although your lordship had already heard me, my lord, if I may
Yes.
make allowed to make submission to recapitulate the facts of the case for my
Yes,
own
yes,
benefit, my
yes.
lord. Page 34, my lord, page
page
34.
34.
My prayer portion, it will be clear from here. My prayer portion, my Lord. A, the impugned award 10 of 2023 should not be interfered, modified by directing the respondents to pay compensation under the 2013 Act with all the consequential benefits. And B, the respondents' MADC should not be directed to release the deducted 10% cess to the petitioners immediately. C, the respondent number 4, DC Sieha, should not be directed to make assessment of interest. This is for delay payment
Yes.
under Section 80 of the 2013 Act, and thereby to direct the respondents BRTF to sanction the assessed amount and make payment to the petitioners. And D, the market value of the lands of the petitioners should not be enhanced in proportionate. I have 4 prayer, my Lord, and coming to the referred judgment which I have just furnished to your Lordship.
D, wait, 1, 2, 3, 4.
Yes,
Now
my lord.
here, this D,
It's,
market
they
value
are all
of the
taken care
lands.
of by this judgment. It's all referred here. I have just furnished to your Lordship.
Okay.
WPC number 103.
You see, at the time when the acquisition was made, now anything to come, okay, WPC number
103, my Lord.
103.
In this case, my Lord, if you turn to the next page, my Lord, WPC number 60 is also there. There are 2 petitions clubbed together in this case by this judgment. And this was disposed by judgment dated 21/11/2024. And if I may take your Lordship to para 13:13.
So the value of the land has to be reassessed
Yes, my Lord.
when,
It's all taken care by this judgment.
you see.
And
anyways,
regarding the
let's-
cess also, Lordship, number 6, it's already taken care of in this judgment order regarding the cess also.
No, cess is a different matter,
If-
but here he has prayed for the reassessment of
Yes,
the
my lord.
value of the land.
It's squarely covered by this judgment, my Lord.
Okay.
I'll come to that.
Para?
From para 13 onwards, my Lord. I
13,
will read
okay,
from
let's
here.
see.
Yes, my
Ah.
Lord. From the projection made by the petitioners, 3 issues have been raised. Deduction of 10% cess from
Yes.
the cost of the land as awarded by the collector, payment of interest under Section 80 of the Act of 2013, and enhancement of market value of the land at par with the rates admissible to the other parts of the states. Insofar as the imposition of cess is concerned, the same is found in Section 23 under Chapter 5 of the Act of 2018 Act. This is MADC Act.
Yes, yes.
Power has been conferred to the Executive Committee of the MIDC under Section 23, 1 of the same Act, to issue a public notification or an official order levying or collecting cess from land, amongst others. Further, Section 23, 2 of the same Act, subject to Section 22 of the same Act, the Executive Committee by public notification or by official order can collect levy cess to the extent of 15% from the value of land for conducting spot verification, survey, and measurement, or any other administrative work or other ways, as provided and advises under Section 22 of the Act. The Act of 2018, however, does not provide for deduction of cess from the amount of compensation awarded to the landowners for acquisition of their land, if the cess deducted is to be considered as the amount towards the expense for the conduct of spot verification, survey, and measurement, and for other administrative works. The summary of the award at serial number 8 otherwise has already provided for administrative costs at the rate of 2.5% of total compensation. Therefore, it only appears that there is no justification for deduction of 10% of the total cost of land towards cess from the compensation to be received by the landowner for acquisition of their
Okay.
lands.
So in the instant case also, administrative costs have
Yes,
been
my lord.
deducted?
Yes.
Where is it?
Yes, my lord, come to me. Page number 66, my lord. This is the award number 10 of 2023. And the relevant portion is in page number 69.
Okay.
Serial number 8.
Okay, administrative cost 2.5 has
Yes,
been,
my
there.
lord.
Okay, so it's the same, covered.
And coming back to the said
Yes,
judgment, my lord,
yes.
para 15. As for the second issue, which is in respect of payment of interest for non-payment of compensation at the time of taking possession of the land, the same is the prescription of the Act of 2013, and therefore the petitioners cannot be deprived of such benefit. The summary of the award apparently does not contain award of interest under Section 80 of the Act of 2013. Such being the position, the grievance projected by the petitioners in this regard is found to be legitimate and needs to be redressed. Lastly, in respect of the
yes,
claim
this
for
point
enhanced
D,
market
huh.
value of the land by the petitioners, Chapter 8 of the Act of 2013 provides for establishment of land acquisition, rehabilitation, and resettlement authority in the mode and manner as prescribed under. The state respondents in the counter affidavit in WPC number such and such have stated as follows: that with regard to the statements made in para 15 of the writ petition, I say that since the Mizoram Act of 2016 is sub judice before the division bench, the government of Mizoram could not establish the so-and-so authority. If the Honorable High Court desires to constitute the said authority, the government of Mizoram is ready to constitute at any time. From the above abstract, according to the state respondents, as the matter relating to the Act of 2016 is sub judice before the division bench of this court, the state could not establish the authority. However, during the course of the argument, this court has been informed that the issue pertaining to the Act of 2016 has been decided by the division bench of this court in writ appeal numbers 70 and 71 of 2018, White Judgment and Order dated 30/10/2024. The writ appeals filed by the state respondents against the judgment and order of the learned single judge holding that the Act of 2016 is not applicable has been upheld by dismissing the writ appeals. Therefore, there appears to be no impediment in constituting the land acquisition, rehabilitation, and resettlement authority now. Upon due consideration of the matter in its entirety, the following directions are made. The MADC Act of 2018 does not contemplate deduction of cess from the compensation to be received by the landowners, and therefore, deduction of cess made from the amount to be received by the petitioners is only illegal. Hence, the amount so deducted should be refunded to them within a period of 2 months from the date of receipt of certified copy of the order. The district collector concerned shall determine the date of taking over possession of the land of the petitioners after giving them due opportunity of hearing along with the BRTF authorities within the period of 2 months. Upon such determination, the collector shall assess the amount of interest payable to the petitioners and forward the same to the Union of India, who shall, upon receipt of the same within a period of 2 months, deposit the amount so assessed before the collector for disbursement to the landowners.
This is interest payable.
Yes, my
Okay,
lord.
this is, then,
The state respondents shall, within a period of 3 months from the date of receipt of certified copy of this order, establish the authority in terms of chapter of so-and-so of the Act of 2013. Once the same is established, any person interested and who has not accepted the award may make a reference in terms of Section 64 of the Act of 2013. And the application so made shall be considered in accordance with law. This is in respect of the market value.
okay, so what does section 64 of the Act say?
It's a equivalent provision as reference.
Oh, okay, so,
So my lord,
so the market value, whether it should be enhanced or not, that if
That
you
has to
are
be dealt with
unhappy,
by
you
the-
can make a reference to the court,
Exactly.
isn't it?
In terms of
So,
this order.
whether to enhance
So, my lord,
or not,
by this,
we will leave it at the,
Yes, my lord.
with, up to the reference court.
yes, my lord.
Okay.
By this judgment
Okay.
rendered in WPC 103/2023, the direction 1, 2, 3, 1, 2, and 3 are
Similar
relating to,
direction may be given in this
in
case.
respect of my prayer to B, C, and D, B, C, and D,
Yes,
respectively.
B, C, and D, yes.
And as for the prayer A,
Oh. Where is a conclusion of B, C, and D?
yes, my lord. And there's separate order rendered by this court on
Another
another
order?
judgment, yes, my lord.
Okay.
WPC
Dated?
125/2021.
Hmm.
In this WPC 103, my lord, compensation was paid under the Act of 2013. And in this 125, it was paid under 2016 Act.
2016, okay. So
And-
this is more covering your case because you have also been paid under 2016, isn't it?
Yes, my lord.
Yes, so concerning your
From para 6, my lord, para
Yes.
6. in respect of the other claims made by the petitioners, that is refund of sales
Yes.
amount deducted from the compensation to be received by them at the rate of 10% of the market value. It may be stated herein that this court in WPC number 103, 2023 and 60.
So refer to its own judgment.
my Lord.
Yes.
This is
What do you
regarding
mean?
says, and para 7 also regarding the constitution of the authority, and para 8, upon perusal of the materials available on record and hearing the learned counsel for the rival parties, the writ petitions are disposed of with following directions. The petitioners shall, within a period of 3 weeks, submit their respective application before the district collector, giving all details of their land which was acquired for the aforementioned purpose, specifying the amount that they have already been received.
So that is covered by the
Yes, my Lord.
first order, isn't it? The first judgment. So you can go to the reference court concerning the assessment that is
Yes,
to be
my Lord.
made. It depends on the reference court whether it's required to reassess the amount or not, the market value or not, isn't it?
Yes, my Lord.
We'll leave it at
Yes,
that.
my Lord.
Yes.
So,
So we'll dispose it off accordingly.
yes, my
Anything
Lord,
to
in line
say?
with this WPC
Huh.
103.
Since they are covered by these, then you have filed another, okay, this is the 71. So this matter, as per the submission of the petitioner, is fairly covered by the judgments of the two judgments cited by of the coordinate bench. Yes, anything to say, the respondents?
My lord,
Or
only
can
one
we-
thing, my lord. That 10% so deducted, my lord. It has not been given to the MADC, my lord. It is still kept with the.
So
district collector.
wherever
there
it
in the
is, it
affidavit.
has to be returned,
My lord.
isn't it?
Yes, only.
MADC or the Kala,
Because in their prayer, it is-
Deputy Commissioner's Office.
My lord. So,
Anything else? That's it?
Covered by the earlier order.
Covered the matter? Yes. Then we'll pass the order accordingly.
Yes, my lord.
Since it's covered and disposed of. I'll pass the order later. Yes.
thank you, my lord.
In this case, the state respondents in their affidavit at para 10, they have stated that the deducted sales is still lying in the office of the Deputy Commissioner.
Yes, only.
Para 10.
That's a submission made by them also,
Yes,
not
madam.
disputed. Yes. Yes,
I-
disposed of, and I'll pass the order accordingly, being a covered matter.
Not obliged.
Item 4.
This is a jail appeal. Anyone appearing? Additional PP? Where have they disappeared? This is a jail appeal. Filed for setting aside and quashing the judgment and order in SC number 81/2017
May it please your lordship, this is an appeal against the impugned order dated 22/10/2024, passed by the Court of Civil Just Senior Division 5 Aizol in review number 6 of 2024, arising out of heirship certificate number 1428 of 2023, wherein the lower court has held that the father of the deceased and the sister of the deceased would have locus standi to contest the claim.
Father and sister.
Father and
Yes.
sister.
And why you're saying,
I am the wife. And in terms of Section 31 of the Mizo Marriage, Divorce and Inheritance of Property Act 2014, there is a hierarchy of inheritance. And the sister would only come if there is no wife, no sons, no daughters. And there is
okay,
no
let's
provision
see
for
the
the father.
impugned
as well.
order. Let's see the order.
Yes, my lord.
Page.
At the beginning, just after the index. The operative portion would start.
This is a review petition which was disposed of. is
Yes,
it?
my lord.
So, it is a review of which order?
It is a review of my heirship certificate. I had obtained heirship certificate before the trial court after duly publishing notice in the
Okay.
newspaper. And since there was no local newspaper at the Zwangtui locality, which was duly certified by the local council chairman, thereafter heirship certificate was issued to me. However, my husband, father, and
The sister.
the sister, after the death of my husband, has entered into our home and chased us out. And thereafter, they've filed an application for review. And though Section 31 of the Act, which I've mentioned earlier, clearly states that the property left behind by the
okay.
deceased father will be inherited by the sons who are not indung and the surviving wife of the head of the family equally. And we have two minor sons, my lord. And now they have chased us out, and the trial court has specifically
Okay, the
stated
trial court had allowed the review
The
of
review.
the heirship certificate issued on the grounds that it came to know that there's a brother, there's the father and sister surviving who wants to challenge the heirship
yes,
certificate.
they stating that they have
Facts,
locus
okay.
standi.
Fine, will issue notice, let's
Yes, my
see
lord.
what do they have to say.
Yes, my lord.
Yes, heard Mr. Zoram Chana, learned counsel for the appellant, who has filed the instant appeal under section 17 within brackets 2, close bracket, then again within bracket small b, close bracket of the Mizoram Civil Courts Act, read with section 96, comma 104 and order 43 CPC against the impugned order dated 22/10/2024, passed by the Court of Civil Judge within brackets Senior Division, close bracket, dash, Roman 5, comma, Aizol District, in review petition number 6/2024, arising out of heirship certificate case number 1428/2023. The learned counsel for the appellant submits that the learned trial court had erred in allowing the review petition since the respondents do not have any locus standi in the instant case as per section
31.
31 of the
Mizo Marriage, Divorce, and
yes,
Inheritance of
Mizo
Property
Marriage,
Act.
Divorce and Inheritance
Inheritance of property.
Inheritance Act, comma,
2014.
2014. Full stop. Issue notice to the respondents through registered post with AD within 3 days, returnable by 3 weeks. List after 3 weeks. Yes.
Obliged, my lord.
Item 6.
Another jail appeal. The same order as before. Yes.
My lord, Miss Mary is on it.
What? Okay, Miss Mary is the counsel for respondent, state respondents. is it?
Yes, 1 and 2. I am for number 3, my lord.
Okay, Miss Valentina Laldinpui, learned counsel for the, yes, Miss Malswamy, can we take up the matter?
This, yes, this matter is handled by Miss Mary. And if this matter can be taken up some other day, Lordship, she has some personal difficulty today.
Okay, Miss
I'm just
Valentina
adjourning on
Laldinpui,
behalf of her.
learned counsel for the petitioner is present along with Mr. Zolan Sana, learned counsel for respondent number 3. Ms. Malswamy appears on behalf of government advocate appears on behalf of Ms. Mary Elkiante, learned government advocate, submitting that since the matter is taken up by Ms. Mary Elkiante, this matter may be adjourned for 1 week since the learned government advocate is not able to appear due to some personal difficulties. In view of the above submissions, list after 1 week.
If the matter may be fixed on 2nd of December, my lord, with your permission.
Is it after 1 week?
Yes, my lord.
List after 1 week on 2nd, 12, 2024.
Much obliged.
Yes, my lord. For orders, item 8.
Yes.
Your Lordship, as per the court's order dated 18/10/2024, steps was taken upon respondent number 5 by way of dusty service, Your Lordship, on 2011, and the copy of the notice was served to the said respondent number 5, and the same is also duly signed, Your Lordship, and thus the application regarding the same is also filed, Your Lordship.
Were you asked to serve notice to Dusty?
Yes, Your Lordship, as per the court's order dated 18/10/2024.
Yes, anyone representing respondent number 5? Let's see affidavit. Who is respondent number 5?
Respondent number 5 is the
Okay. Engineering projects, is it?
yes, Your Lordship.
Miss.
I apologize, madam. I take it over from here. She's not appearing in this case formally. I take it over from here.
So
have
you're
filed-
saying that notice has been, Dusty service has been served
We have taken
upon,
steps upon the respondent number
respondent.
5, and we have filed this affidavit indicating the service of notice upon the R5 by way of Dusty. We may await service
But,
reports
yes, we'll
for the
await
time being.
for-
And if
some time.
LCR may be called for, LCR.
Uh, heard Mr. Victor L. Ralte, learned counsel for the appellant, who submits that notice has been duly served to respondent number 5 by way of dusty service, and he has filed the affidavit to that effect. On perusal of the affidavit, it is seen that notice is served to respondent number 5. Accordingly, notice is deemed to be served upon respondent number 5. However, none appeared for respondent number 5. Yes, Miss?
Respondent.
Yes, standing there.
Lordship,
Miss?
I appear on behalf of my senior, Mr. Ketang Remsanga.
Okay.
Counsel for respondent number 3 and 4.
Okay, Miss so-and-so appears on behalf of her senior, Mr. K. Thang Remsanga, learned counsel for respondent number 3 and 4. Anyone else? No. In view of the above, we may wait for the respondents number 5 to be duly represented, lest after 3 weeks.
Yes, my lord. In the meantime, the LCR may be called for.
In the meantime, LCR may be called for.
Much obliged.
Item 9.
Your Lordship, I'm the counsel for the applicant in the instant case.
What's the IA about?
Yes.
This IA is about continuation of delay. There has been a net delay of 1,396 days, Your Lordship. And the reason for the delay is that
Anyone appearing for the opposite party?
Yes, my lord. But this case may be will be taken up by the senior counsel from Shillong. So I
Who
have.
is he?
So
Have you
if
filed your written objection?
yes, I have already filed my written objection.
This is a criminal appeal, is it?
Yes, criminal appeal.
Against. So you are representing whom?
The sole
No,
respondent.
the respondents. So who's the respondent in this matter?
This case is about NIA complaint.
a criminal complaint.
Criminal
Okay, a criminal complaint.
Yeah.
under
Under which
negotiable
section?
instrument act.
Let's see. So the state is not a party or what?
Yes, not a party. This is private.
yeah,
two
private
private
matter.
Okay, this
parties.
is 138 of the Negotiable
yes.
Instrument Act. Money. Huh?
Yes. Check bouncing case.
What is the amount involved?
22 lakhs. And apologies, Your Lordship.
It's and then we'll wait.
27 lakhs, 22,739 to be exact.
So the counsel from outside the state, he can appear through VC also. His person.
Yes, I would
So
tell.
why is he absent today?
My lord, the problem is that when this hearing is posted on 30th of August, they came, but the opposite party adjourned the matter. Then from that moment, there is no fixed date.
Okay, Mr. David, is it?
Malsomkima, yes.
Malsomkima, learned counsel for the applicant slash appellant is present, while Mr.
J.H. Ramney Moya.
J.H.
Ramney
Moya
Moya.
appears on behalf of the respondent. The learned counsel submits that this matter, the leading counsel in this matter is Mr. K.
Paul.
Paul, senior advocate, and since the learned senior advocate is not able to appear today, he has prayed for adjournment of the matter. In view of the above, list, we'll fix a date.
Yes, if it is possible, 6th of December, that is Friday.
Okay, in view of the above, as prayed for, list on 6/12/2024.
Much obliged.
Item 10.
Yes.
My lord, in this matter, as
Okay,
per the last order.
yes, the one which you mentioned in the morning, isn't it?
No, no, my lord, this is another matter. This is regarding
Okay, the
custody of a
one you
child.
mentioned is in the part 2 list.
Yes, yes.
Yes. So what is this
My lord,
about?
both parties have agreed to refer the matter to Lok Adalat, my lord.
Okay.
This
Oh,
is
this is the guardianship
custody, yes, my
matter.
lord.
Yes. Okay, good. Try, advise your clients
My lord.
to settle the matter because children are not properties that they have to be owned only by one person or pushed around, isn't
Exactly.
it? And impress upon their clients that the child needs both the parents, and it's very important for the child that the parents have a good environment. Amicable settlement would be in the best interest of the child.
That's true, my lord.
Okay. Mr. Rokung Pautu, learned counsel for the appellant, is present along with Mr. C. Tlang Thiang Lima.
Lan Tiang Lima.
Now, Mr. Igro, learned legal aid counsel, okay, instead of counsel. And Mr. C. Tlang Lima, learned legal aid counsel for the respondents. Both the learned counsels submit that the parties are willing to have their matter referred to Lok Adalat, considering the fact that this is an issue for the guardianship of a minor child who is aged approximately 3 years?
3 years
3
approximately.
years. In view of the above submissions, this court find it fit to refer the matter to the Lok Adalat to be organized by the High Court Legal Services Committee. Accordingly, registry to do the needful. Yes.
Okay.
For hearing, supplementary cost is item 12.
Yes, this is the matter, huh?
My lord.
So your appointment, do you have the rules?
I have the soft copy, I have PDF copy, my lord.
Oh, because this court has not passed any order
Exactly.
for your appointment as a legal aid counsel,
Exactly.
but your appointment, rule what?
Rule 5(2)(a).
Rule 5(2)(a). Wait, I don't think we are on the same page. Regulation. Okay, it's not rule, it is regulation.
Yes, my lord.
I was looking at the rule. So page 11. The index is also wrong. Yes, 5(2)(a), yes. Let's come to rule 5 first. It shall be the duty of the, yes, read from rule, regulation 5(2). Read.
My lord.
Not 5(2)(a), but start from 5(2), regulation 5(2). Please read.
Without prejudice to the generality of the functions referred to in clause 1, the committee shall, for the High Court in consultation with the executive chairman, state authority, perform all or any of the following functions, namely: A. Provide legal services to persons who satisfy the criteria laid down under the Act and the rules. B. Conduct Lok Adalat for High Court cases. And C. Encourage for the settlement of disputes by way of negotiations, arbitration, and conciliation.
Okay. So since the previously what engaged counsel
My lord.
has no objection, we'll allow, isn't it? Heard Mr. C. Thiang Lima, learned legal aid counsel, who submits that he has been appointed as a legal aid counsel provide the order dated 29th May 2024. In terms of regulations 5 within brackets 2 within brackets small a of the Mizoram State Legal Services Authorities Regulation, 1998. Uh, 1998, and that the previously engaged counsel by the appellant, Mr.
Bilaram Eng.
Bilal Ramenga, has not objected to his withdrawal from the instant case. Having heard the submission made by the learned counsel, the learned legal aid counsel, and on perusal of the Regulation 5 within brackets 2 within brackets A of the Mizoram State Legal Services Authorities Regulation, 1998, this court find it appropriate that the that Mr. C. Tan Tiang Lima should appear on behalf of the appellant as a legal aid counsel. Accordingly, it is also seen that since paper book is prepared, a copy of the paper book to be duly furnished to the learned legal aid counsel. Good stuff. What else? This is under which section?
This is under
Respondent number
POXO
2
Act, my
required?
lord.
POXO?
So, yes, my lord, the respondent number 2 is also, I believe, she's not represented. It's under section 10 of the POXO Act.